Today we're going to have an asynchronous class. What that means is I'm posting videos and you can watch them at your leisure, then do the assignments so that I know you've watched these videos and so that I make sure that you get from it what you need to get. So just for starters, let's situate ourselves. Where are we so far? Last class, we were looking in depth at section 553, at what the rulemaking process is, right? So we looked at what an informal rulemaking requires. We looked at the obligation that there be notice in the Federal Register, right? The NPRM that we looked at in environmental integrity, and that there be an opportunity for the public to comment and share impressions and opinions and information about that proposed rule. And then the agency must publish the final rule, in which that publication has to explain how the agency took into account the comments that were submitted in reaching the final rule. Right? And what we looked at for last class is that this final rule has to be the logical outgrowth of the proposed rule. Right? So today, we're going to do something a little bit different. We're going to talk about when does section 553 apply, which is called informal rulemaking, and then we're going to talk about what formal rulemaking is. Now, to start with that, you should know that formal rulemaking is almost never required. And the cases that we're going to read today are the reason that formal rulemaking is almost never required. And then, just to give you a heads up where we're going, right, the exceptions that you folks wanted to talk about to section 553, we are going to talk about, but we're going to talk about them in the next couple of classes after we look at our rules that we're going to be commenting on. So, just to remind you, under section 553, there has to be a notice of proposed rulemaking published in the Federal Register, and it has to include a couple of things. The time, place, and nature of any public proceedings. If there are going to be hearings, they have to be specified in the notice of proposed rulemaking. And then it has to identify the legal authority under which the rule is proposed, as well as the details of the proposed rule, right? And then the comment period, right? We spent a lot of time talking about that last class, and this is what we are going to be developing our participation in over the next couple of classes. What does it mean to participate in a comment period? So we talked last class, again, when we were talking about the logical outgrowth, we were talking about the comment period and the outgrowth of the comment period in terms of the final rule. Now today we're going to look at a different section of 553 that we skipped over last class. And that is the language that says, when rules are required by statute to be made on the record after opportunity for an agency hearing, section 556 and 557 of this title apply instead of this subsection. Right? So what this section means, this language in section 553, it says that there are other sections of the APA, section 556 and 557, that apply to a subset of rules. Rules that are required by statute to be made on the record after an opportunity for agency hearing. And the cases that we read for today are about what this clause does and does not mean, when it is implicated, and what happens if it is. The choice between using section 553 informal rulemaking and section 556, 557 formal rulemaking, as we'll see a little bit later on, is very significant in terms of the amount of process that has to be given to parties, the formality, the structure. 556 and 557 really describe trial-type proceedings. Okay, so let's look at the first case I asked you to read today, Florida East Coast Railway. What this case is about substantively is a little complicated. There was a shortage of railroad cars, and the Interstate Commerce Commission was trying to create incentives for railroads not to hoard their cars. The details about it don't really matter that much. What matters is that what's going on here is that the railroads are challenging the choice that the Interstate Commerce Commission made, the way that it decided to structure tariffs to create this incentive not to hoard the boxcars, on the ground that the Interstate Commerce Commission didn't use the appropriate procedures. And so this is a procedural challenge to the rulemaking. And the argument that the railroads are making is that this decision should have been governed by Section 556 and 557 of the Administrative Procedures Act. In making that argument, this is the language of the statute that the railroads point the court to. The statute says, after notice and an opportunity for a hearing, the Interstate Commerce Commission should establish reasonable rules, regulations, and practices, etc. Right? So the question is, what does that language mean in terms of going down the path of Section 553 or Section 556 and 557? Now remember that Section 553 said that whenever the agency was directed after notice and an opportunity for hearing on the record, that's when Section 556 came in. This language here says after notice and opportunity for a hearing, and that's what they're litigating. Now let's look at Section 556 and see why this might matter. Where Section 553 directed that the agency shall give interested persons an opportunity to participate in the rulemaking through submission of written data, views, or arguments with or without opportunity for oral presentation. Section 556 does something very different. If you look at the language that is highlighted, right, Section 556, which governs formal rulemakings, says a party is entitled to present his case or defense by oral or documentary evidence, to submit rebuttal evidence, and to conduct such cross-examination as may be required for a full and true disclosure of the facts. So Section 556 contemplates something much more like a trial-type proceeding than does Section 553. And I think you can see why a party that's trying to block a rulemaking or shape a rulemaking might want to have these kinds of procedures at their fingertips. So we already looked at part of the statute. Let's look at the other part of the statutes that the railroads are relying. The railroad points to this language. In determining the rates of compensation to be paid for each type of freight car, the commission shall give consideration to, right, and then a bunch of facts. So the railroads are arguing that this requirement that the commission give consideration to these factors in conjunction with the earlier language about the decision being made after a hearing, the argument says this triggers the formal proceedings in Section 556. And the court makes fairly short work of that argument. So the answer we get from this case is that the phrase in a statute, after hearing, does not by itself trigger 556 and 557. The court says the statute must have language equivalent to on the record after hearing. So that magic phrase on the record has to be part of the hearing. Now, the court also says, well, you know, there's no magic language here. They could do this a bunch of different ways, but that has turned out not to be true. Unless the organic statute says something like on the record after agency hearing, courts are pretty clear that informal rather than formal processes are required. Now, notice the analysis here, because there are two separate questions. What does the APA require, and what does the organic statute require? And it's the interplay between the language of the APA and the language of the organic statute that tell us which procedures are required. Because Section 553 of the APA says, except where decision has to be made on the record after opportunity for agency hearing, then the general Section 553 informal rulemaking of notice and comment is going to apply. But the APA doesn't tell us when that happens. You have to look at the organic statute and see exactly what the organic statute says to see whether Section 553 applies or Section 556 and 557. And we've only looked at the briefest snippet of what Section 556 and 557 apply because they really don't apply in rulemaking. We'll look at them in much more detail in the context of adjudication because that's where you see the triggering language and that's where you see formal processes being required. Okay, so we're going to be done with the Florida East Coast Railway case. I'm going to make a separate video about Vermont Yankee. But before you watch that, or I guess afterwards if you want to, I would like you to write a brief paragraph, 3 to 4 sentences, explaining how the court in Florida East Coast Railway justified not requiring a formal. After you watch the Vermont Yankee case video, I would like you to answer the question of why did the court even have to decide that case when they had already decided this Florida East Coast Railway case? As a second paragraph, I would like you to explain very briefly the difference between formal and informal rulemaking as contained in Section 553 versus 556 and 557. You don't need to go into detail. I just want a very brief outline of 1 or 2 key differences and how you think those differences might matter. What's an advantage and disadvantage of each approach to rulemaking? See you in video 2.